International Covenant on Economical, Social and Cultural Rights, that is ICESCR. So there is a close relation between them, and it has been rightly released especially by the developing countries that civil and political rights can have no meanings unless they are accompanied by the social, economic and cultural rights. Thus, both categories of rights are equally important, and where civil is and the political rights do not exist. So, they cannot be full realization of the economic, social and cultural rights and vice versa. So, what are the international human rights law? So, international human rights laws has been developing extensively since the creation of the United Nations. The most fundamental point about the human rights law is that it establishes a set of rules for all of the peoples of all the states. So, human rights is the international in the sense of it being universal, which applying to all the individuals. However, international human rights laws refers mainly to the obligation of the states to the individuals within their jurisdictions. When states fails to assure a realization of human rights to the individuals within their jurisdictions, international obligation arises. Thus, obligations to provide human rights individuals is mainly intranational and in some cases international. So, thus, the state is not free to treat its nationals as it pleases despite the fact that it is sovereign. Because the sovereignty, as we studied in the previous videos, the greatest impact of human rights laws has been to erode the absolute control which states had in the classical period. The efforts for the creation of the international organizations in order to establish peace were being made even when the World War II was in progress. Many declarations adopted by the conferences laid down the importance of the human rights. The Declaration of the United Nations, signed on the January 1, 1942 at Washington, and was the first documents which used the term human rights. Thus, the human rights became a matter of international concern with the end of World War II and the founding of the United Nations. Since then, international human rights laws has been developing in an unprecedented way and has become a very substantive part of international law as a whole. Although there is no global government as such to protect human rights, it is being protected by the various bodies of the United Nations and the governmental organizations. So, what are the promotions and protections of the human rights by the United Nations? So, the prime responsibility of the promotions of the human right under the United Nations Chartered rests in the General Assembly, in economic and the social counseling and its subsidiary body, that is the counseling of human rights. The term protection of the human rights, which may mean implementation and enforcement actions, does not find place in the United Nations Charter. When human rights violations assumes massive dimensions, the General Assembly and other organs of the United Nations can initiate discussions and actions. Among the United Nations agencies, only the Security Council and the International Court of Justice can engage in enforcement actions. Only they have a competence to pass a binding resolutions or issue a binding judgments. Enforcement is thus the authoritatively applications of the human rights. The United Nations in the past has been able to promote and protect the human rights by certain way, which are as follow. Number one, the human rights consciousness, that is the first and the most important role which the United Nations has played is that it has made the people and states conscious about the human rights and the fundamental freedoms. Second one is the codifications of the law of the human rights, that is the United Nations has codified the different rights and freedoms by making the treaties for all sections of the people, such as women's, child's, workers, refugees, etc. The Counseling on Human Rights. The Economic and the Social Counseling, that is ACOSOC, a principal organ of the United Nations, was mostly directly concerned with the questions of human rights. The counseling under Article 68 of the UN Charter was empowered to set up commissions for the promotion of human rights and such other commissions as may be required for the performance of its functions. The counseling may also meet annually in Geneva for 6 weeks beginning in the March. So the commission may also meet between the annual sessions to deal with the urgent human right situations. So the counseling, that is the economical and social counseling as determined by its terms of references, was directed to the prepare recommendations and reports on the following items. So number one, on the International Bill of Rights. Second one is the International Declarations and Conventions on Civil Liberties. The status of women and freedom of information. The protection of minorities. The preventions of discriminations on grounds of race, language or religious. Next one, the Universal Declaration of the Human Rights. The idea for the protection of human rights and the fundamental freedoms was conceived in the Atlantic Charter in 1941 and in the Declaration of the United Nations, that is in 1942. The Universal Declaration of Human Rights was adopted in 1948 with an aim to enumerate human rights for all the people. The UDHR has inspired a rich body of legally binding international human rights treaties, and it continues to be an inspiration to the all, whether in addressing injustice in time of conflicts and in our effort towards achieving the universal enjoyment of the human rights. Next one is the preamble of Universal Declaration proclaim the declaration of common standards of achievements of all peoples and all nations. The Universal Declarations contains 30 articles. It enumerates the basic principle of human rights in a most comprehensive manner. Out of 30 articles, while 21 articles enumerated civil political rights, 6 articles covers the economic and social rights. So it is to be noted that the Universal Declaration does not permit a state to derogate from their obligations in public emergency which threaten the life of the nations. Thus, even in such cases, the rights cannot be suspended. Legal effect of the declarations. The Universal Declaration set for the international community common standards of achievements. That is, it recognized the inherent dignity and the equal and inalienable rights of all the peoples in all nations. So, it is the duty of states, regardless of their social, political, economical systems, to promote and protect the human rights. The Universal Declarations was not the intended to be legally binding and therefore it did not impose any legal obligations on the states to give the effect to its provisions. In other words, from the legal point of view, the declarations was only the recommendations and not strictly binding on the states. The declarations addresses right to all the peoples and all nations, whether they are members of the United Nations and or not. The main object of the declarations was to present the ideas of the human rights and freedoms in order to inspire everybody to work for their progressive realizations. The message conveyed to one of the hope, equality, liberations, and empowerment. The international humanitarian laws. The international humanitarian laws is a branch of international laws and which provides the protection of the human beings from the consequences of the armed conflicts. That is, humanitarian laws deals with those matters which have an impact of armed conflicts on the lives, that is the personal integrity, liberty of human being. Thus, the humanitarian laws, it may be referred to that body of the law which defines those principles and rules which limits the use of violence in times of wars. So these rules are inspired by principle of humanities and they are meant to avoid human referees and brutality in armed conflict. However, those rules of the war which are based on humanitarian considerations or the motivations are called as humanitarian laws. So international humanitarian laws has much in common with the laws of human rights since both is concerned with the protection of the individuals. Nevertheless, there are important difference between the two. First difference is that international humanitarian laws is applied during the time of armed conflict, whereas law of human rights is applied in a peacetime. The second difference is that the state which becomes a party to human rights treaty assumes an obligation to treat all person within the jurisdiction in accordance with the provisions of the treaty. So humanitarian laws is primarily made up of treaties, agreements between the states intended to have binding legal effects between the parties that have agreed to them and are binding only between the states which are parties to those treaties. So the international humanitarian laws applies to all armed conflicts, that is the international armed conflicts as well as non-international armed conflicts. So international conflicts may mean an armed clash between two or more states, whereas non-international armed conflicts which takes place in the territory of the states between its armed forces, that is the civil war, are included in non-international armed conflicts. So there are some case studies. Malala Yousafzai, a Pakistani schoolgirl known for her activism for rights to education and for women's specialty in the Swat Valley, where the Taliban had at times banned girls from attending school. After this, United Nations, specially Enoch for Global Education, Gordon Brown launched a UN petitions which helped lead to the ratifications of Pakistani first right to the education bill. Over the years, many forms of discriminations have come to be recognized, including racial, gender, sexual discriminations. Another type of discriminations is against LGBT individuals, that is the lesbian, gay, bisexual, and transgender individuals. So, human right violation in Sri Lanka, the conflicts in Sri Lanka has been one of the greatest occurred in human violence. In this case, the government of Sri Lanka and separatist liberation tigers of Tamil Elam LTTE are accused of violating human rights. LTTE were known as the most vicious and dangerous terrorist groups in Sri Lanka. And finally come to the conclusion that presently there is a widespread acceptance of the importance of human rights in the international structure. However, one will not hesitate to admit that there is a confusion prevailing as to its precise nature and scope and mode of international law as to the protection of these rights. One valuable lesson that the history of human rights teaches us is that they are not static but are developed in response to new model of political thoughts and changes in the international environment. Thank you.